Are you public servant and facing prosecution under Prevention of Corruption Act? Then this video is for you. I will tell you how to protect yourself from this case. Dear friends, Prevention of Corruption Act is enacted as amended in 2018 for curbing the menace of corruption from the society. It is not an ordinary act. Its procedure is quite different. For the registration of FIR, information is sufficient which discloses the commission of cognizable offence. But our lawmaker is fully aware about that when there is a law, there is chance of abuse. And here, the Prevention of Corruption Act deals with the corruption done by or will done by the public servant. Then there will be abuse by any person who want to interfere with the government policy, government work. So it is easy for any person to falsely implicate any honest public servant. we will we see it day in and day out that how our greedy, malicious people lodge false FIR under this act, and therefore there are certain safeguards, such as when information is received which discloses commission of cognizable offence, then police officer is duty bound to lodge an FIR under the light of Lalita Kumari versus State of Uttar Pradesh judgment passed by Honorable Supreme Court, that look, if a person coming to the police officer saying that this incident happens to him or happened to anybody, and if that information discloses the commission of cognizable offence, first information report will be lodged. There is no permission for doing a preliminary inquiry. But in the cases relating to Prevention of Corruption Act, when information is received to the police officer that look, this person is indulged in the corruption, then police officer is duty bound to do the preliminary inquiry. And how the preliminary inquiry will be done, that is very unique methodology in the Prevention of Corruption Act. We have to understand that there is two authority which prosecute a person, a public servant. First one is the central machinery such as ED, CBI, and there is a state machinery for the state government employee. How will be the public preliminary inquiry will be done? It involves in three phases. Firstly, when an information is received to the officer in charge that look, this person is demanding some money to do this work which is he is duty bound to do, then it is duty upon the investigating officer that before lodging an FIR there must be a preliminary inquiry. How the preliminary inquiry will be conducted? Then that he will depute a person to do that inquiry regarding to his reputation in the society. Further, he has to record some voice recording, some conversation that yes, he is on call and demanding some illegal gratification for doing some work which is pending before that person. Once this information is confirmed that yes, this person is demanding illegal gratification, then there is formation of trap team, and then trap team will conduct the trap procedure in this trap procedure we have to see that there this also in three parts. A pre-trap memorandum will be prepared, then trap memorandum will be prepared, then post-trap memorandum will be prepared. In a pre-trap memorandum, he will that the trap officer will explain all the events which is going to be occurred, such as they will take some money, put up some phenolphthalein powder over that currency. That trap officer will show that, look, we have put the powder or a chemical over these currencies, and then wash out that hand of that officer who put the currency, and show the other officer that, look, that person is touched that currency and put this powder over that currency, so the water which is washed out is of red color. And if this currency will be touched by the accused, then his hand, water of his hand will also become red. After these, following these procedure, a trap will be conducted. When that officer took the money, then they will arrest him, and it is mandatory that his procedure of washing of hand should be done at the place of occurrence, and there must be a shadow witness. In today's time, that shadow witness is provided by the other department on the request of trap team officer. If that is relating to central government, there may be some officer from post office or from railway or other department. If there is a state department, then employee of state government from the office of Vikas Bhavan, development offices, department relating to water department, irrigation department, agricultural department. Two officers will be nominated to watch as a shadow witness that the accused will demand money. Their work is to watch and listen that he is demanding money and accepting the money. So you have to be very careful that whether the preliminary inquiry is done properly, whether the verification of the reputation of the alleged accused is done properly, whether the pre-trap memorandum is done properly, whether the post-trap memorandum prepared accordingly, and if it is not, then there is good chance of acquittal. Apart from this case, if you got trapped into the case, you have to face two other prosecution, but it depends upon the agency. One is disciplinary proceeding arising out of your service rules, and in this proceeding you will get the stay from the honorable court on the ground that facts involved in the disciplinary proceeding and facts involved in the criminal case, that is trap case, is identical and sub judice before the judicial court. Therefore, till the outcome of that case, this proceeding should be kept in abeyance. Third one is open inquiry of your disproportionate asset, that what you earn and what you spend will be matched, and if it is more than 20%, you will be prosecuted under section 13 of the Prevention of Corruption Act. So be careful and don't lose hope. Justice will prevail. You have to only see whether the preliminary inquiry is done accordance with the law, whether the pre-trap memorandum and post-trap memorandum is done accordance with the law, and if there is disciplinary proceeding, you have to give the reply that both matters have identical facts and circumstances. So this proceeding must be dropped till the conclusion of trial. But if it is not done by the authority, you can invoke the writ jurisdiction again and get stayed on that proceeding. And if there is a inquiry relating to your disproportionate asset, you have to be very careful. You have to take care of your ITR, bank statements, and property details which is mentioned on the human resource portal. After getting all these information, you will able to fight this case. It is a very hard case. It is not so easy. It is at very different footing. It is not lodged by a private complainant, because in these cases informant is a trap team officer who lodged these FIRs, and every witnesses is a government employee. Whatever they write, IO has right. They will going to speak verbatim everything same. Even in the court, the prosecuting officer will record the chief whatever mentioned in the case diary. He is trying to write down exactly. So you have to be more brave. You have to be hire a brave advocate who go against this convention, and chief must be done accordance with the law, because in a trial court, advocate practicing from the defense side, they're not going to disturb the proceeding, because they don't want to become bad in the perception of judge. When a defense advocate interrupt the prosecuting officer on several times that look, this is a leading question, this should not be asked in such manner, this should not be right directly from the case diary, most of the time we see that judge don't like that advocate, and that advocate has to fight several cases. Some is good, some is easy, but if he going to fight in such a manner that the prosecuting officer facing difficulty to get his job done in what manner he thinks, then it will be not good for the image of the advocate who is fighting for you. So there are very few advocate who has courage to say to the prosecuting officer that look, this is not the right way to get recorded the examination in chief. You can't ask the leading question, you can't give the case diary to only read out, and what he is reading, the steno is recording that statement before in the presence of judge. Next time when we will meet, we will discuss every aspect in a very fine manner, so you can get what question would be asked in a cross examination, on what judgment you can rely to save yourself, what will be the procedure to get quashment of the Prevention of Corruption Act, But dear friend, in a very few circumstances when there is there is no trap trap was not successful, in that cases it may be possible, otherwise there are very few chances to get quashment of the cases registered under Prevention of Corruption Act. You can find what I am saying is that the Arvind Kejriwal liquor scam case, here in this case the session court discharged the Arvind Kejriwal and their associates from framing the charge. And look what happened, that the government appealed that order in the High Court, and it is damn sure that the High Court is going to frame the charge, because quashing is something very difficult. That the criteria in which the quashing can be done is only the two ground, after studying all the relevant statements, perusing of the case diary. If no offence is made out, then case can be quashed, or you can prima facie establish that the present case is a malicious abuse of process of law, it is a vexatious and frivolous process, then it is going to be quashed. But only on the basis that some procedure is not followed, something is not done accordance with the law, it is not good ground for the quashment of the FIR under the Prevention of Corruption Act. So stay tuned with us. I will discuss the every aspect of Prevention of Corruption Act, how it is enacted, how we can fight, what is the view of honorable high courts of several states, what is the view of Supreme Court, what are the methods used in these cases, what is the views of the court on the several aspects of these several facets of the Prevention of Corruption Act. Stay tuned. Thank you.